It says preparing to live stream the meeting. So just a couple
All
seconds
right,
and yeah.
I think
Go
we're
ahead. Okay.
live.
We are live. Yes.
We ready?
Yes,
Yeah.
we are.
All right. Well, welcome everybody. Good afternoon. My name is Cecile Carlson. I am a program coordinator here at the Office of Neighborhood Engagement with the Department of Neighborhoods in the City of Houston. With me on the line, we also have Diana Paredes from Neighborhood Recovery Corporation. And with us, we have two guests who will be talking today about bankruptcy basics. But before we get started, I just want to talk a little bit about who we are, what we do. We are a month of service, which is a collaboration between the City of Houston, Lone Star Legal Aid, Houston Volunteer Lawyers, um, Texas Legal Services Center, Earl Carr Institute, Harris County Tax Assessors and Collectors Office, and together we make a month of service. We bring education to the community on a variety of topics to empower the community to learn and to have information directly from the sources. Today we are joined by Mr. Elias Yazbek and Ms. Jayla Carter, and they will be talking to us about bankruptcy basics. This information is very important. I know a lot of us are not sure of how to navigate, and bankruptcy sounds like a very scary thing. But together we're going to learn just how to navigate that process correctly. Just as a disclaimer, we do not offer legal advice. If you have any specific questions, make sure that you enter them in the chat, but just remember that we are live and so other people can see what you are asking. So just make sure that you're not sharing any sort of personal information. And if you do have questions that need a little bit more attention, please say that in the chat and then we'll go ahead and connect you to the experts. So without further ado, I'm going to go ahead and let our presenters go. And thank you so much for being here.
Yeah, thanks. Well, hi, everybody. I'm Elias Yazbek, and I'm a bankruptcy lawyer in Houston, Texas. I am here today with Miss Jayla Carter. Jayla, say hi.
Hello, everyone. My name is Jayla Carter, and I am also a bankruptcy attorney here in Houston.
And today we were gonna just talk to you a little bit about like the high level points about bankruptcy. What is it, how it can help a debtor, and why a debtor should file, when a debtor should file, and what the process sort of looks like. And if at any point you want to ask questions, you can put them in the chat here on Zoom. I know that we're also monitoring the live streaming, so you can put the questions there too, and we'll try to answer them as they come in. If we don't get to it, maybe we can get to it at the end. I have 1:09 p.m. and I'm thinking this presentation will go until about 1:35 or so, or 1:40. So first things first, I'm going to go ahead and share my our little presentation Jayla and I prepared just to sort of guide us through the process. This is our contact information. We'll also come back to this later on. So I think it's important to start with what is bankruptcy. So bankruptcy is essentially a federal system, federal process that goes back a long time, but it has been codified in Title 11 of the U.S. Code, and it essentially enables a debtor, whether they're an individual or they're a company, they're small business, to seek a discharge of their debts. You know, debts is kind of qualified asterisk by certain kinds of debts. Some debts are not dischargeable. Some debts are dischargeable only under certain circumstances. But generally, that's what everybody who files for bankruptcy is after. They're after a discharge of their debts. And they can do that really in two basic ways. They can either liquidate all their assets, or they can get a reorganization plan confirmed. You hear about Chapter 7, Chapter 11, Chapter 13. The liquidation one is Chapter 7, and the reorganization ones are Chapter 13 or Chapter 11, depending on if you're dealing with an individual or a business. Chapter 11 is for businesses. Chapter 13 is for individuals. And I have on the screen sort of like a really simple, basic idea of like what it is that we're doing. So you talk to a bankruptcy attorney, they help you determine whether or not you want to file. If you determine that you want to file, once you file, something called the automatic stay automatically kicks in and essentially serves as like an injunction against all your creditors from basically making collection efforts against you. And this also will stay any lawsuits against you, foreclosure actions against you on your home or your personal property. Everything sort of stops once you file. At that point, what's really important is that the debtor is honest and transparent with the bankruptcy court. And you're going to file that, you're going to file a bankruptcy petition with the bankruptcy court with your attorney. And you're going to disclose a lot of information, which is why it's important to sort of anticipate when you're going to file, because you're going to work with your attorney to kind of gather these materials before you file. And you're going to disclose the assets you have, the liabilities you have, whether or not you have a regular income, who's suing you, who's coming after you, who your creditors are. You're just going to put everything on the table, and you're going to say, here's kind of the situation I'm in, and I'm seeking a discharge. And then from there, you go through the process, and creditors will appear with their own attorneys, and you'll have your attorney, and you'll go through the process, whether it's a liquidation or a reorganization. And that's sort of the high level how bankruptcy leads to a fresh start, quote unquote. And I'll actually let Jayla see if she wants to opine real quick before we get into some of the different parties that are involved. Jayla, any thoughts?
Yes, I mean, I feel like you hit a lot of the important pieces here. I definitely would recommend that if bankruptcy is something that you are considering, that you absolutely talk to a bankruptcy professional. So that way you have all of the information that you need about the pros of bankruptcy, the cons of bankruptcy, and if that is the best decision for you. Oftentimes, when I am having initial consultations with potential clients, I ask them why they want to file for bankruptcy and what has kind of led them to that decision. And I also tell them to consider, possibly, is bankruptcy the best option for you? I can't tell anyone whether they should or should not file bankruptcy. That's a personal decision. But considering some of your options with whether or not it makes the most sense for you to do that, or should you be exercising another option? Elias was absolutely hitting the nail on the head about once you file the bankruptcy petition with the court, it puts an automatic stay on debt collections, meaning it just puts a pause on creditors trying to collect debts from you or trying to collect the money that you may owe out. And that can be a big stress relief to many debtors. But it is so important that you are honest with not only the court, but if you opt to file with an attorney, you are honest with your attorney. Your attorney is here to help you through this bankruptcy process, but they're only able to help you as much as you're allowing them to help you. So you have to let them know the full story of what's going on. I know that bankruptcy can kind of feel like a mountain and can be overwhelming, but it definitely is something that can be very beneficial to you, but you have to understand how the whole process works. Are we answering questions out of the chat?
Yeah, we can get into it. I kind of foresee this being sort of a free flow conversation. So, I mean, one of the questions we just got are what are the pros and cons of filing a bankruptcy petition yourself versus using an attorney? Well, I mean, I'm sure Jayla has a lot to say about that, but I think just right off the cuff, I would say that bankruptcy is complicated. Like I mentioned, it's all sort of based on a federal code, Title 11 of the U.S. Code. It's probably one of the most complicated areas of law, in my opinion. And there's a lot that can go wrong. Creditors will do everything they can to get them to recover as much as possible out of your bankruptcy process. And I think that's also a good opportunity to talk about the different stakeholders in the bankruptcy process. And so I think I have up now a slide that sort of simply shows all the different parties that might be involved. Jayla, do you see that?
Yes, I see your slide.
Yeah. So I kind of have two pictures here. This one is maybe a little better. So in the middle, we have the debtor. So you're in the middle, you're filing for bankruptcy. And right when you file, all your creditors, whether they're customers, banks that you owe money to, everybody will start appearing in your bankruptcy. You have to notify everybody that you're filing for bankruptcy. So, if you don't have an attorney, you may not be notifying everybody properly. Even if you get past the filing part, even if you file your petition and you disclose everything, there are even more requirements. So the first thing is you gotta notify everybody. You have to appear before a United States trustee, or sorry, not a United States trustee, a trustee. There is a United States trustee, but that's another trustee. You basically have these watchdogs who will appear in your bankruptcy to make sure that everything is going well, and they will have requirements. They'll require you to disclose financial documents. They will question you under oath and in front of your creditors, and they will require you to pay certain fees and file a plan if you're trying to reorganize. All of those things are something that an attorney can help you with, and it's very hard to navigate those things, those requirements, without assistance. Even backing up a little bit, figuring out which chapter you want to file for, 7, 13, 11. I mean, these are all decisions that you need to make with an attorney. You can try to figure it out yourself, but if you file for the wrong one, you may be ineligible. You may have different requirements that you have to fulfill before you can get to the discharge that you're seeking. And all of that is very technical, very financially intensive, and requires a lot of inter-party communication between creditors, trustee, the judge, going to court, etc. So filing for bankruptcy, I think a lot of people think it's just filling a form and you file it and it's a get out of jail free card, but it's just not that at all. Jayla,
I agree.
thoughts?
Yes, I agree, Elias. Circling back to the question in the chat, I like to use a lot of comparisons. So I kind of compare it to working out with a trainer versus working out in the gym on my own. Can you file bankruptcy on your own? Absolutely. Is it something that is super easy? Like Elias said, it can be pretty complicated. I can hire a trainer in the gym and let the trainer know exactly what my goals are, and the trainer will help me accomplish those goals. So that's the way that I would view a bankruptcy attorney. It's oversimplifying the example a little bit, but your bankruptcy attorney is an expert in bankruptcy. He or she should be able to answer all the questions about what is beneficial about bankruptcy versus what is not. What chapter would you be the best candidate for? Making sure all your forms are completed correctly. Being able to explain things that may come from the court or documents that come from the court. Explaining it in a way that you're understanding what's happening through the process with each step. Just like working out in the gym, you don't need a trainer. You can work out on your own, but it does require a lot more discipline and for you to be looking things up on your own. Filing bankruptcy on your own, there is so much paperwork. You are managing a lot of things and keeping up with deadlines and learning different things, like different classes you're required to take, things that need to be filed with the court, keeping up with making sure you're reporting all of your creditors to make sure that they're included in your bankruptcy. It is not impossible to file on your own, but it does make the situation a little bit more complicated. Sometimes you just have the security of knowing everything is done more correctly if you are working with an attorney. Like Elias said, there are a lot of aspects and levels to different parts of the bankruptcy and there are a lot of people involved in it, you might feel a little bit more secure dealing with the attorney who has a bit more experience with the entire bankruptcy process.
Yeah, thanks. I totally agree. All right. Well, we discussed, I think, what is bankruptcy and how it can help somebody. Maybe now we can talk a little bit about, why a debtor should file, or when a debtor should file. At what point, does it make sense to file for bankruptcy, and what are the implications? Why put off filing for bankruptcy? I think is an important question that a debtor would think about. Um, in my opinion, I think that an individual who's looking to file would want to file at the point when they're when basically they're being pursued. Like there are lawsuits filed against them. There are garnishments against them. They're being foreclosed on. To me, I think that's probably the point where you should really start to consider it. I think that I put on the screen a little flow chart that I tried putting together that kind of breaks down maybe the decision making. And you'll see right at the beginning, right at the front there is like, are you struggling to pay your debts? Yes. Are you facing lawsuits, garnishments, foreclosures? I think if the answer is yes to that question, bankruptcy is likely, at that point beneficial. Um, before that point, you may want to consider non-bankruptcy options like saving more money, or simplifying how many expenses you have, or doing what you can to make more money, creating a budget, renegotiating your debt with lenders. Um, I think the incentive to do that is that filing for bankruptcy is not something you can do an infinite amount of times. You are only eligible to do it within, there needs to be space between when you file and when you can try again. And then, that timing, how much time you have between filing dates will depend on the circumstances of your case, whether your case was dismissed or not for non-compliance, and what kind of bankruptcy, you're filing for, 13 or 7. Jayla, any thoughts on that?
Yes. So I do agree with you about debtors taking a good look at their finances to see if bankruptcy makes sense for them. Are your expenses drastically exceeding your monthly income? That is something that I always tell clients to take a look at. Is it exceeding your monthly income, but maybe you can readjust some things in your budget? Maybe eating out a little less, or calling up some of the creditors and trying to negotiate a few things, or however those small adjustments might help you level things out each month so you're not ending up in such a deficit. That could be helpful, and it could be an alternative to filing for bankruptcy. If your expenses so drastically exceed your income that you're not able to provide for your monthly needs, like buying groceries, maybe bankruptcy is something that you should consider, or it doesn't leave enough money every month for you to take care of all of your monthly obligations. You're always upside down. Bankruptcy might be something that you should consider, also taking into account some of the other things that Elias mentioned, like you're at risk of foreclosures, or things are being garnished, or what have you. And like Elias mentioned, you are only able to file bankruptcy every so often. In a Chapter 7 specifically, you're only allowed to file those once every 8 years. So you won't be able to file another Chapter 7 if you get yourself in another financial bind and you feel like bankruptcy is the route to go. If 3 years later you're in the same boat, you're not going to be able to file another Chapter 7. He said that there are certain exceptions, and this is true, but typically it makes it a lot more difficult. Also, trying to get certain debts taken care of, a bankruptcy is not going to typically cover them, like student loan debts and IRS debts, things like that. There are certain exceptions to these rules, but in a pretty typical case, you're not going to be able to get those things discharged. So looking at the type of debt that you're going to have included in your bankruptcy, whether or not the bankruptcy is going to be beneficial for you. I think there's another question in the chat.
Yeah, if a consumer is extremely overwhelmed with unsecured credit card debt, I think this is a typo. I think, and they are at risk of being sued, should they consider it?
I would say it would depend. Before I could answer yes or no to that, I would say that it depends. We'd have to take a good look at the entire debtor situation.
Yeah, I agree. It's not going to be contingent on just that decision. It may be that, that you have some options to consider before deciding to file. Well, all right. I guess now I wanted to kind of zoom in a little bit and talk a little more about the different chapters. In the big buckets, you have reorganization versus liquidation. But I think more specifically, especially in the case of individuals, which we can focus on, your options are generally 13 or 7. There are other chapters, but those are the two big ones. I guess right off the bat, chapter 13 or chapter 7 is not something that everyone is immediately eligible for, and it will depend on whether or not you have a regular income or not. And another thing that that will be considered is whether or not you're trying to basically protect some non-exempt assets that you don't want to turn over. If you are, then chapter 13 may be a better option, where you pay back your creditors via a reorganization plan, perhaps not in full. That will depend on the rights of each creditor. But in exchange, you'll be able to retain some or all of the assets that you want to retain. And I have this table here where I kind of break down everything, but generally between 7 and 13. There are a lot of pretty big differences between them. But before we get into it, Jayla, you want to talk a little bit more about the difference between the two?
Yes. So typically, when I'm advising clients on what would be their better option, the chapter 7 or the chapter 13, we're looking at if this client has assets or not. Some people own multiple homes or multiple vehicles and things to that effect, or they have businesses that they're trying to protect. That would be at that point where I would recommend possibly a chapter 13, but also in a chapter 7. Ironically enough, if you have just one singular use vehicle or you have a home that you own, you can still file a chapter 7 and retain those assets. You can retain your car, you can retain your home. What we usually would do is reach out to that creditor and see if the creditor is willing to do a reaffirmation agreement, which is basically reaffirming the debt on that asset. So I've seen that the creditor will want the loan terms to remain the same. So your interest rate usually will remain the same. The amount of months that you have remaining to make the payments remains the same. But reaffirmation agreements are typically, from what I've seen, offered to debtors who are not several months behind. A couple of months, maybe like 1 or 2 months, they're willing to move some of those missed payments to the end of the loan. But for things that are like 6 months and beyond, it is very difficult to get the creditor to agree to a reaffirmation agreement in a chapter 7.
Yeah, and I think that what Jayla was also saying about if you're filing for a 7 and you still may be able to keep your home or your car, for example, that has to do with exempt assets that are exempt from creditor action, and which exemptions apply and which ones you are choosing to exercise is a legal intensive question. Going back to the question about, well, hiring an attorney or not hiring an attorney, that an attorney would probably be extremely helpful in figuring out. Another high level thing is that, a Chapter 7 is typically a 3 to 6 month process. A reorganization plan is, a 3 to 5 year repayment plan process. Again, also there's some qualifications that are required if you are to file a Chapter 7 versus a 13 and vice versa. And the impact on your credit is different. If you think about it from a common sense standpoint, if you're repaying creditors over time, that is going to be probably less detrimental to your credit than, um, a 7 liquidation, discharging that debt and not paying anything back. Another thing that just popped up in the chat that I think we can address is in what instances is a bankruptcy petition denied? I think if you're not honest in your disclosures, that's probably a really big one. If you're trying to hide certain transfers you made right before you filed your petition, those, you know, are seen as efforts to try to essentially hinder your creditor's abilities to exercise their rights under the bankruptcy code, and that can get your case dismissed, as well as not fulfilling all the different trustee requirements that come with filing all the different disclosure requirements. Jayla mentioned a class that is sometimes required to be taken on being more financially responsible. That's one that, again, is not abundantly obvious if you're filing without an attorney, that you need to jump through that hoop. But that's one of those non-compliance things that can get your case dismissed. There will also be hearings and creditors meetings that are that are noticed, and if you don't show up for those, or if you show up and you're not ready and you're not ready to answer questions and put your disclose your identity, basically turn on your camera. I mean, these are all things that I've seen that lead to bankruptcy petitions getting denied. Jayla, any other thoughts?
I think that you hit several of them, but mostly just not being honest with your bankruptcy trustee and also with the court in your bankruptcy filings, and not complying with the things that maybe the trustee has asked of you. I've seen petitions get denied or dismissed because debtors won't file their tax returns, and it's something that the trustee is asking for copies of. And if you haven't filed the returns, then you have no copies to provide. You're just not adhering to what the trustee is requesting of you. So sometimes people's petitions do get dismissed. The next question in the chat is, does the case remain open in court for a Chapter 13 until the payment is complete? And what is the most effective way to negotiate with creditors?
The case does remain open until the end of the plan, is my understanding, and it's it's not, there's not going to be a lot going on, but I think there are some reporting requirements, and creditors can still file things if you default on payments, or are not doing what you said you would do in your reorganization plan in a Chapter 13 situation. The discharge is not issued until you complete your plan. So the case is gonna remain open until you finish. Is that right, Jayla?
Yes. So from my understanding with the way that Chapter 13s work, like you mentioned, they file a plan, and the plan does go for 3 to 5 years, and the plan is where you make payments to the trustee to pay your creditors for debts that you owe. And in order for creditors to make a claim for how much you owe, they file something called a proof of claim. The trustee takes all of this information and compiles the creditors into a list and creates an order for which the creditors are to be paid as you are making those payments to the trustee over the allotted time of the plan until the bankruptcy discharges.
Yeah.
And I think, go ahead.
No, you finish your thought.
I was looking at the second part of the question in the chat, asking about what's one of the most effective ways to negotiate with the creditors. Again, I think that that's kind of there's no direct answer to that. It just really depends, because it's up to the creditor about whether or not they're willing to negotiate on balances or debts that are owed to them.
Well, I will also say this. I mean, that's really where your attorney comes in. I think and adds the most value, and why it's important to hire a good one is because the creditors are going to negotiate based on the rights that they have under the bankruptcy code. So, in order to negotiate with them, the most effective way to negotiate with them is to know what are their rights and what are they entitled to under the bankruptcy code and what are they not entitled to under the bankruptcy code. And that is your leverage. It's the knowledge of what they're entitled to if push came to shove and you guys had a contested hearing over, certain treatment you're proposing, or if your creditor is being unreasonable. And to be honest, I find that would be a very difficult process without the help of with an attorney. I mean, as soon as creditors are filing things in your case and trying to negotiate certain treatment and objecting to things like your discharge or your proposed plan, I mean, you need to know what you're entitled to and what you're not entitled to, and what the creditors are entitled to or not entitled to negotiate.
I agree. I think that was a great explanation, Elias.
Thanks. Well, I mean, that's the lion's share of what is bankruptcy, and and I think we can open it up for a couple more questions. Okay, I meant for clients pre-filing. Okay, so question about negotiating with creditors before bankruptcy. Well, I would say that you want to look at the documents that are governing your relationship. So that may be an attorney intensive process or not, but I mean, a place to start is looking at your loan agreement. What are the, it also depends on who you're dealing with. I mean, if you're dealing with a credit card company, you want to basically know more about consumer protection laws in order to negotiate with them. With more secured creditors where there's like collateral securing their loan, or like a car or house or whatnot. That you want to look at the law, but also your relationship with that creditor is governed by the loan agreement, or the security agreement that you entered with them. So I would definitely review those documents.
I agree. Definitely something that you want to take a look at if you're looking to renegotiate or negotiate balances that may be owed to that creditor. Definitely need to look at the documents that you've signed. I always recommend to everyone that before you sign an agreement, especially for borrowing money for something, you definitely need to have a pretty clear understanding of the terms of the agreement, just so you know what you're getting yourself into. And should you find yourself in a situation where life is lifing, for a lack of better term, and you may find yourself in a situation where you need to file for bankruptcy, I always try to encourage people that filing bankruptcy may come across as a very scary thing, But as long as you have the proper guidance, it's not the end of the world. You're not a bad person because you may find yourself in a situation that you need to file for bankruptcy. Think of it as an opportunity for you to get a retest. Like, you're getting an opportunity to try again. And you just have to be careful about the decisions that you're making for your financial well-being moving forward. And if bankruptcy is not the decision that you need to make at that time, and there are other options that you have available to you to exercise, I would seriously take a look at those and just kind of assess, how did we get ourselves into this situation, and what are some steps that I can take in the future to make sure that I don't end up back here. But life gets complicated sometimes, so definitely understand exploring different options with just trying to get your financial situation in order.
All right. I think that was a great presentation. Thank you, Jayla, for doing this with me, and thank you to Lone Star Legal Aid for providing us this opportunity to educate the public. Um, I'll pass it back to Lone Star to see if they want to make any concluding comments.
Yes, hi. So I did not introduce myself, but my name is Jessie Campbell. I am with Lone Star Legal Aid, and I am going to just replace the screen real quick. Just 1 second. There we go. And so I am a supervising attorney with Lone Star Legal Aid. We are a legal aid service provider here in the Houston area, but we serve 72 counties in the state of Texas, in the eastern third of the state, with 13 branch offices. And we provide free legal services to eligible households based on income and assets, and all of our services are free for eligible households. We are one of the partners in AMOS. There are other partners as well. And so, so this was a great presentation. So that way you have an understanding of what bankruptcy means. And if you find yourself needing assistance in that, in addition to Lone Star Legal Aid, Houston Volunteer Lawyers, another partner of AMOS, is a place that you can apply for services. Another partner is the Earl Carl Institute. I don't know if they take bankruptcy cases, so that's why I didn't highlight them. If you are in a position that you don't qualify for services and you want to hire an attorney, the Houston Law Referral Service is a service of the Houston Bar Association. That's where you can find attorneys in the private bar that can help you. Those will be attorneys like Miss Jayla and Mr. Elias here. They are part of the private bar. And thank you so much for presenting again. But and then also for those of you who just want a little bit more information, you're kind of exploring that possibility of doing self-representation or going pro se, or you just are like, I need a little bit more, I'm a visual learner. A great website for you to take a look at is Texas Law Help. That's a self-help site. It has a lot of information, not only on consumer bankruptcy issues, but also on family law, estate planning, all those various things. And that's managed by another AMOS partners, which is Texas Legal Services Center. But feel free to apply for services. I always say, don't assume you don't qualify for services. It's estimated as high as a third of the state qualifies for representation. So just kind of be aware of that. And that's pretty much it. I'm going to kind of see if there's any remaining questions, but I don't see any. So I think that unless one of our other partners likes to hop on, I'm going to say thank you very much. You will get a copy of the recording, so that way you can watch it at a later time, and then you can see the resources and watch it again, get some more information. And I think that's it. Please check out our information for our upcoming presentations in the next couple of weeks, and we'll see you next time.
Thank you,
Thank
everybody.
you.
Thank you. I was looking for the bottom.
All right.
Yeah.
I think we're good.
Right.
You need anything
Yeah.
else for us?
No, thank you.
Thanks. Good night. Or good night.
Good
Good afternoon. Bye.
afternoon. Bye-bye.